Okay, so I think we all probably have this kind of philosophical thought sometimes, like when is it really like right when is it just for the law to kind of like step in? Like when should it guide our actions and when should it just kind of like back off? Even if we think, that's not the best way to act.
Oh, yeah, definitely. That's like the core tension, right?
Yeah.
Between the rules that we like all agree on and the freedom we want as individuals.
Yeah.
So today, that's what we're diving into, the limits of law.
We're using a pretty cool source for this, the Stanford Encyclopedia of Philosophy entry on the limits of law. It's really in depth. It's like having this super detailed map of all the philosophical ideas about, when and why we draw legal boundaries and like when we shouldn't.
And it's not just, some abstract academic thing. It gets into really practical stuff like how does law relate to our own personal morality? And why do we feel like we have to follow laws? And then there's this huge question that keeps popping up. Should the law even try to make us be moral?
Right. So get ready because we're going to dig into some big ideas. We'll look at different philosophical viewpoints and why they make sense. And we'll try to figure out, where those limits of legal intervention should actually be.
Exactly. And for you, our philosophically minded listener, it's all about unpacking these core debates and frameworks, getting some clarity, and maybe even walking away with some new questions.
Okay, let's get right into it. Let's start with this idea called legal moralism.
So legal moralism basically says, if something's immoral, that's a reason, a justification for making it illegal. Like use the power of the law to stop it. But being a philosopher, you'll probably want to think a little bit more about what that reason really means.
No, for sure. And our entry reminds us about those debates back in the 60s, especially between Lord Patrick Devlin and H.L.A. Hart. Devlin basically argued that a society has this initial right to, like, make laws against immorality because, that's what they all basically agree on. Like, just the feeling that something's wrong morally is a reason to, like, step in with the law.
Yeah, and the key thing here is that for legal moralists, it's usually seen as a prima facie justification. Like prima facie, it means at first glance. So it means that, like, just on the surface, immorality seems like a good reason to make something illegal. But, and this is where things get really interesting for a philosopher, it's not always enough. There can be other stuff, other factors, what Devlin called factors that should restrict using the criminal law, that can kind of outweigh that initial justification, like things that kind of defeat that first glance reason.
Right. So even if everyone in a society is like, that's so wrong, there might be other really good reasons why the law shouldn't get involved. Devlin himself said that we have to balance things out. And this brings us to one of the biggest, most important restrictive factors: privacy.
Yeah, it's privacy. It's this big thing for legal moralists, guys like Devlin and later Michael Moore. Take adultery, for example. A lot of societies throughout history, they saw it as super immoral. But even Devlin said, no, the law shouldn't be poking around in these private consensual things. Like, how would you even enforce that? It just gets creepy.
Yeah, and it's interesting how Geoffrey Murphy, even though he knew things like marital breakdown could have like a social impact, he kind of came to the same conclusion. Like the state snooping around in personal relationships.
Yeah,
That just outweighs the whole moral disapproval thing. It's like you got to choose.
for sure. And Lawrence Tribe, what he said about Bowers v. Hardwick, he didn't even focus on the act itself. He focused on the fact that the state was, like, in the bedroom. That's what's messed up, right? And then you've got Jeannie Suk's work, which adds this whole modern layer,
Yeah.
especially when it comes to, domestic abuse. Like making that illegal was, morally and legally a huge step forward. But she points out this like balancing act. Like, yeah, we want to protect people, but we also got to respect their privacy, their right to make their own choices. And sometimes some legal tools, like restraining orders, they can actually end up doing something she calls state-imposed de facto divorce. It's like unintended consequences, the law trying to help, but it actually causes other problems.
It's really complicated, right? It shows how much privacy can push back against making everything moral into a law. But then you have Anthony Duff, another legal moralist, who kind of sees privacy differently than Devlin.
The cool thing about Duff is that he's like, privacy isn't just a defeating factor. It's more like the main thing that decides if something is even bad enough for the law to care. For Duff, the criminal law should only be about public wrongs, not stuff that happens in private. That's a way harder line.
So Devlin thought the boundary could move based on what society would tolerate, but Duff is like, nope, there's this private space, and the law stays out no matter what people think about what goes on there. It's kind of more about principles, maybe?
Okay, now let's move on to liberty, another big factor. Devlin, he famously said we need tolerance of the maximum individual freedom that works with keeping society together. And he was careful to say, tolerance doesn't mean you like it. It just means letting something happen even if you don't like it.
And he used some really clear examples, like he thought cruelty to animals should not be tolerated, so the law should get involved. But he also said, which was a big deal back then, that homosexual sex should be tolerated. Now, as a philosopher, you can already see some problems there.
The big question, and philosophers really disagree on this, is how Devlin decided where to draw the line.
Mm-hmm.
He seemed to think that, like, the more people really, really dislike something, the more okay it was to make it illegal. And that's, like, a huge problem, right? Does that mean just because the majority hates something, it's automatically okay to criminalize it? What about, like, minority rights or people who just think differently?
Yeah, exactly. And then you have Michael Moore, who sees liberty a different way. He says there's always a reason not to force people with the law. It takes away their chance to choose freely.
That goes right to the heart of that classic philosophical debate about negative and positive liberty. Negative liberty is all about not having restrictions, while positive liberty is about actually being able to act to make your own life. And this all shows how different ideas about what liberty means can change how we think about legal limits.
Okay, now we come to the crime tariff.
The crime tariff is basically about the bad things that happen when you make something illegal. Even if most people think it's wrong, making it illegal doesn't mean it goes away. It often just goes underground and causes even bigger problems.
Totally. It's like when they tried to ban alcohol, right? Or think about drugs or sex work. Making them illegal doesn't make them disappear. It just means higher prices, more organized crime, violence, corruption, and no regulation, which makes it more dangerous for everyone involved.
Devlin kind of saw this coming. He used abortion as an example. He realized that even if you think abortion is morally wrong, making it illegal could make women go to, like, dangerous, shady places where it's not safe. That's a whole other kind of harm.
Besides those practical problems with the crime tariff, there are other things that matter, especially when you're thinking about this philosophically. Tom Tyler's work shows that people often obey laws because they think they're legitimate, not just because they're scared of punishment. Paul Robinson talks about how laws need to line up with what society already believes, otherwise they just don't work. And then there's this idea of self-defeating crimes that Bill Stuntz came up with, where, like, trying to make something illegal actually makes the problem worse.
And something really important for us to think about philosophically is this growing body of research that looks at how criminal law impacts different groups unequally. Like Barrett and Gauss looked at potential problems, and then you have work from people like Yanka and reports like the Lamy Review. They all force us to face this fact. Criminal law often hits certain racial groups way harder. That brings up huge questions about justice and fairness, and any philosophy of law needs to deal with that. Like, just using the law can create moral problems.
Okay, so what we're seeing is that legal moralism isn't just this simple thing where if something's immoral, it's automatically illegal. You have to weigh all these potential negative consequences and competing values.
Exactly. It's complex. And now, let's look at the philosophy behind this morality that legal moralism is all about.
Right. So as we talked about before, Devlin had a very specific idea of morality. He was a moral relativist. That means he thought right and wrong were just whatever a specific society believed. So for him, the people making laws, they weren't supposed to find some like universal truth about morality, just figure out what everyone already thought. And that's bound to get some philosophical pushback, right?
Oh, yeah, definitely. Devlin wasn't a fan of leaving moral decisions up to some, like, self-appointed elite. But that whole relativism thing, that's been a major problem for people, especially HLA Hart. Like, yeah, major philosophical disagreement there.
Right. And Hart really went after Devlin's disintegration thesis. That's this idea that a society is like exactly the same as its morality. So if morals change, the society falls apart. But Hart was like, no, a shared morality is important for keeping things together, but it doesn't mean every little change in morals is going to destroy society. We can see from history that things change all the time and societies don't fall apart.
Yeah, and any philosophy student knows that just because a society survives, it doesn't mean it's good or just. Like, think about some really horrible regimes in history. No one's going to say those were morally good just because they lasted a while. So maybe Devlin's focus on preserving society isn't the most important thing.
Exactly. And then that makes us think, okay, how does Devlin even justify liberty and privacy if he says morality comes from what everyone believes? What if people don't value those things? It seems like he applies those protections kind of inconsistently. Philosophically, that's kind of messy.
So if we don't buy Devlin's moral relativism, what could legal moralism be based on?
Yeah, what else could it be?
Well, since it's all about prima facie duties, Maybe you could use something like W.D. Ross's idea of inherent moral obligations.
Hmm.
Or there are tons of other ethical theories, like utilitarianism, Kantian deontology, rights-based stuff. Any of those could be used to say what's morally wrong enough for the law to get involved. Remember Michael Moore? He combined legal moralism with moral realism, which says moral truths exist no matter what people think. All of these try to give legal moralism a stronger foundation than just what's popular.
So it seems like the main idea of legal moralism, that morality matters for law, sticks around. But the big question is, where does that morality come from, and how do we balance it with other important values in a fair legal system? All right, now let's switch gears and look at a totally different perspective that's had a huge impact on law and politics: the harm principle.
Ah, yes, the harm principle. Most famously laid out by John Stuart Mill in On Liberty. It basically says that the only time you can use power over someone against their will is to stop them from hurting other people. It's all about respecting individual freedom.
So, unlike legal moralism, which starts with what's morally wrong, the harm principle is all about preventing actual harm. So, you can't use the law to force people to be moral just because something is seen as immoral. And you can't use it to stop people from being offended, at least not in Mill's original, stricter version. And no paternalism either that's interfering with someone for their own good. It draws a pretty clear line about what the law can and can't do.
Exactly. So the state can step in to stop things that directly hurt others, assault, theft, fraud, that kind of thing. But it crosses the line if it tries to stop people from doing things that are consensual, even if some people think it's gross or morally wrong, as long as no one else is being hurt. It's all about protecting individual liberty from the state.
Now, Joel Feinberg, he spent a lot of time working on the harm principle, trying to develop a version that he thought really captured Mill's liberal ideas. He came up with what he called the liberal position, which has both a harm to others principle and an offense to others principle. That kind of expands things a bit.
Right. And Feinberg's harm to others principle, remember, unlike his take on legal moralism, it's not just about whether something causes harm, it also looks at how effective legal intervention would be and whether it would mess with other important values. And then, going beyond Mill, he adds the offense to others principle. He says that preventing serious offense, things that really hurt people's feelings, that's also a legit reason for making something illegal. So he's recognizing that harm can have a social aspect too.
And adding offense like that, I mean, any philosopher would tell you that's a whole other can of worms. Like, what is serious offense? Is it different for everyone? And should it be as important as real tangible harm when we're talking about using the law to coerce people? It's complicated.
But there's another important part of Feinberg's harm to others principle that we got to look at. He's not saying any bad thing that happens to you is harm the principle cares about. For Feinberg, it has to be the result of something that was morally wrong to do in the first place. So he's adding a moral element even within the harm principle.
So, like, if you lose a tennis match or your business fails, yeah, that sucks. But Feinberg wouldn't call that harm that justifies legal action, because it didn't come from someone doing something morally wrong. It's the injustice that makes a setback into harm that the principle is concerned with.
That's it. That's how he gets around all those potential problems that a simpler harm principle would have.
Mm.
But then someone could say, well, hold on, if you're saying some things are only harm because they come from moral wrongs, why not just say that any wrong can be a reason for the law to step in, even if it doesn't cause any clear harm? You just got to consider those defeating factors we talked about before with legal moralism. So is harm really the most important thing here?
And Feinberg, like Mill, really doesn't like hard paternalism. That's forcing someone to do something for their own good, even if they don't want to. But he does make a distinction with soft paternalism, which says it might be okay to intervene if someone's actions aren't truly voluntary or if they don't have all the information. He's recognizing that we don't always make perfectly rational choices.
And it's worth pointing out that not everyone who believes in the harm principle is as strict about anti-paternalism as Mill and Feinberg. People like H.L.A. Hart and Joseph Raz, they're a bit more open to some paternalism, as long as it's done carefully and within limits. It just shows how ideas about individual agency are always changing and evolving in philosophy.
So we're seeing that the harm principle isn't one single thing. It's more like a family of ideas with some important differences, like whether offense matters and if any paternalism is okay. But what ties them all together is this basic skepticism toward using legal moralism as the main reason to force people to do things.
And that brings us to this fundamental question for anyone who wants to actually use the harm principle. What exactly is harm? It seems simple, but philosophically it's super complicated.
It's kind of surprising, but even the big names who love the harm principle don't always give us a clear and complete definition of harm. Mill, he just uses examples and context clues, assuming we all get what he means.
Totally. We can all think of classic examples, broken bones and stolen poses, as Feinberg put it. But in everyday life, people use the word harm for lots of things, like emotional distress or damage to your reputation. And that can overlap with the very idea of wrong that the harm principle is trying to be different from. So the question is, can we come up with a definition of harm that's specific enough and workable enough to actually use the harm principle in law?
One early attempt to, draw the lines around harm, they focused on this difference between other regarding conduct, meaning actions that affect other people, and self-regarding conduct, meaning actions that mainly affect just the person doing them. Seems pretty simple, right?
Yeah, it did. But that neat little division breaks down pretty quickly. Like James Stephen, he said, no man is an island. In a society where everyone's connected, it's almost impossible to find actions that only affect the person doing them. Even Hart, who wasn't totally sold on it at first, seemed to kind of accept this distinction in the context of sexual morality. But the interconnectedness of society just messes with those categories.
Okay. Another big way to think about harm is as a setback to interests. Mill talked a lot about people's interests, so this builds on that. And guys like John Rees and Feinberg really developed this idea, trying to get a more concrete definition. But the problem with this is, what exactly are interests? Are we talking about getting what you want? Or feeling good? Or is there some objective list of things that are good or bad for people, whether they want them or not? Depending on how we define interests, we might accidentally bring back this idea of moral harm that the harm principle is trying to avoid, because an objective list of interests could easily just be someone's idea of what's morally right.
Right, and then there's Joseph Raz. He defined harm as a setback to autonomy, meaning it shrinks your choices and your ability to decide for yourself. This puts the focus on how much agency you have. So this idea of harm is all about whether you can choose freely between good options and whether you have enough independence. But it's hard to apply this when it comes to physical pain or to beings that aren't fully autonomous, like animals or people with really severe mental disabilities. Saying that pain is only bad because it limits your choices just doesn't feel right, does it? It shows the problems with defining harm only in terms of autonomy.
So it seems like anyone who's really into the harm principle needs to really wrestle with the definition of harm itself, because the word can hide a lot of complexity and disagreement, and that affects how the whole principle works. Okay, now let's look at the philosophical reasons people give for the harm principle.
So Mill was a utilitarian.
Right.
He thought utility, the greatest happiness for the greatest number, was the ultimate goal for all ethical questions. But that creates a bit of a problem. How can a principle that says we can't use coercion for harmless wrongdoing, how can that be based on utilitarianism? It seems kind of backwards.
It does, doesn't it? The principle of utility says we should maximize well-being and minimize suffering. But the harm principle prioritizes freedom, even if using that freedom might not make everyone happy. It's a philosophical puzzle.
Yeah. So the common way to square these two is through this idea of indirect utilitarianism. This view says that the harm principle isn't meant to be used in every single case to make people happy right now. Instead, it says that if we have the harm principle as a general rule over time for the whole society, it will actually create more happiness than unhappiness. Mill really believes that freedom was essential for people to flourish, and flourishing leads to happiness.
It's like saying sometimes a general rule leads to the best overall outcome, even if it doesn't work perfectly in every single instance. It's thinking long-term about the good of society. But as our entry points out, actually proving that the harm principle comes from utilitarianism is still a big philosophical challenge. Even John Gray, who worked a lot on this connection, ended up saying it doesn't really work.
That's true. But modern consequentialists are still trying to find ways to connect the harm principle to utilitarianism or similar ideas, and there are also non-utilitarian arguments for it. Like Les Green suggested, there might be good reasons to have an absolute rule like the harm principle, even if the reasons for that rule aren't always perfect in extreme cases.
And it's interesting, some philosophers who are totally into utilitarianism or consequentialism, they actually reject the harm principle. They think that sometimes to really maximize well-being, you need to do more than just prevent direct harm. There's definitely debate within those schools of thought. Now, let's switch gears again and look at another philosophical foundation for the harm principle: perfectionism.
So perfectionism, particularly as Joseph Raz talks about it, has become a really important way to understand the harm principle. It might seem a little strange at first because perfectionism generally says that governments are allowed to promote things that are morally good and discourage things that are morally bad. Raz even says that there's no real reason why governments shouldn't act for moral reasons, and that seems to clash with the whole idea of limiting the law with the harm principle, right?
Right. If perfectionism says the law can be used for moral goals, why would someone like Raz, who's a perfectionist, also support the harm principle, which seems to limit those goals? It's a bit of a philosophical head scratcher.
The way Raz gets around this is by separating the goals of the law from the methods it uses. He thinks it's fine for the law to try to make life better for people and discourage bad choices, but it has to do this in a way that respects autonomy. And that's where the harm principle comes in for him.
So for Raz, coercion is a big problem for autonomy. He says it messes with your ability to make your own choices, especially when you're talking about serious stuff like prison. It's that image of the state being heavy-handed that he's worried about.
But this argument, although it makes sense, runs into some problems when you think about all the different tools the law has besides just locking people up. Jail definitely takes away your autonomy. But other things, like fines or community service, they might not have such a huge impact on your choices and your independence. There's that famous example of the soccer player, Jermaine Pennant, who was still able to play professionally even though he had to wear an ankle monitor. So is Raz's argument about coercion really true for all forms of legal intervention?
And even when the law uses serious force, is preventing harm really the main reason to limit it? Raz himself says that coercion can just be disrespectful, like a form of domination. But couldn't you also say that forcing someone to stop them from hurting others is also disrespectful, even if you're doing it to protect other people's autonomy? It makes you wonder if it's really just about preventing harm, or if it's more about setting limits on state power and respecting people's independence, which is kind of like what Ripstein talks about with his sovereignty principle.
Which leads us to the last big philosophical framework we'll look at today. Public reason. This adds a whole other kind of limit on the law, and it comes from John Rawls. It's not about harm or morality directly, but about how we justify legal principles in a society with lots of different beliefs.
So public reason, the way Rawls explained it, is this idea that laws, especially the really important ones about basic rights and justice, should be based on reasons that everyone can understand and accept. It doesn't matter what your personal beliefs are, morally, ethically, or religiously. The justification has to make sense to everyone.
Think back to when we were talking about decriminalizing homosexual acts. Devlin, Moore, and Hart, they all thought it should happen, but their reasons were totally different. Some were relativists, some were realists, some were concerned about individual liberty. Rawls would probably agree about decriminalization, but he'd say it has to be based on principles of justice that everyone can get behind, not on specific moral or perfectionist arguments that might be controversial. He wanted to avoid what he called trying to shove the whole truth into politics, because he knew people have different beliefs.
So Devlin focused on whatever the majority of people in a society felt. But Rawls had this idea of an ideal citizen who understood that people will disagree about important stuff and that those disagreements are reasonable. Legal justifications have to respect those differences.
And of course, that whole idea of an ideal citizen, it gets debated a lot in philosophy. Some people question if there really is a neutral ground between just accepting what people already agree on and finding reasons that are universally true. Natural law theorists, like John Finnis, they argue that law should come from things that are inherently good, regardless of whether people agree or not. That's a completely different way of thinking about justification.
And it's important to note that public reason isn't just about how we agree, it also has content coming from a family of reasonable conceptions of justice. So even if you can't use your specific beliefs to justify a law, the values behind those beliefs can still be part of this framework of public reason. It's not like values are totally absent.
Right. And there are big questions about how far public reason goes and what it can actually do. Rawls mostly used it for the most fundamental stuff about rights and justice. But some people say that's too limited, and it leaves out other important issues of justice and fairness. And then there's the question of whether public reason can even handle seemingly simple stuff like why murder is illegal, without relying on exactly those moral and philosophical ideas it's trying to avoid. The debates about Rawls' view on abortion are a great example of how complicated this all is.
Okay, so public reason gives us a lot to think about when it comes to limits on the law. It says we need justifications that make sense to everyone in a diverse society. But it also raises questions about how far it goes, how idealistic it is, and whether it can actually solve every legal problem without going back to those deeper moral and philosophical questions.
Exactly. And finally, when we're thinking about limits on the law, we have to go beyond just what the law should do. We need to think about what makes something law in the first place.
Right. It's about the very definition of law, not just when to use it. And thinkers like Lon Fuller, who talked about the inner morality of law, he said that for rules to work as actual law, they got to have certain qualities. Like they got to be general. People got to know about them. They got to apply to the future. They got to be clear. They got to be consistent. These aren't just nice to haves. They're like part of what makes law law.
And building on that, legal theorists like Kristen Rundle and Jeremy Waldron, they say that legal positivism, which focuses on where law comes from, like socially, might be too accepting of systems that don't meet these basic standards of legality. They say there are, like, built-in limits to what can be called law, limits that go beyond just what we think is right or wrong.
So instead of just asking when to use this tool of power, we're asking what makes this tool a legal tool in the first place. Not every command backed by force counts as law.
And another interesting point is to broaden our view of what law can do. Robert Summers showed us that it's not all about coercion and punishment. He found all these other legal techniques, like education campaigns, incentives, using publicity, setting up regulations, all kinds of stuff.
His work reminds us that the law has a whole toolbox for influencing behavior. It's not just about banning and punishing. When we look at legal issues with this bigger picture in mind, we might find new ways to think about the limits of law and how to use it most effectively. It's like a more sophisticated approach to legal problems.
So as we wrap up this deep dive, it's clear that figuring out the limits of law isn't easy, and there's no one right answer. We've gone through legal moralism and the harm principle, wrestled with defining harm, looked at the philosophical reasons behind these ideas, and thought about public reason as a way to limit legal justification.
And as we've seen, each of these approaches comes with its own arguments, its own strengths, and its own weaknesses. The question of where to draw the line between individual liberty and the power of the state is still a huge philosophical question, and it's one that keeps evolving.
And so we leave you with this thought-provoking question. Where do you, in your own philosophical thinking, draw the line between individual freedom and the right of the state to enforce morality or prevent harm? And what are the core principles that shape that boundary for you?
It's a question worth thinking about, and it shows how complex this whole topic is. If you want to go deeper into these ideas and hear what all these philosophers had to say, definitely check out that Limits of Law entry in the Stanford Encyclopedia of Philosophy. It's full of great insights.
Thanks for joining us on this deep dive. We hope it helped clear some things up and got you thinking more about these big questions of law, morality, and how to balance freedom and justice in society.